Welcome once again to Lehto's Law. Here's Steve Lehto.
I seem to recall a skit on Monty Python where a man wrestled himself. So the announcer came out and basically said, in this corner, we have the challenger. And the guy comes out, and then in this corner, he points to the same guy. We have the champion. Guy comes back out. And then once the whistle blows, the man wrestles himself. So, who wins? Who loses? Is it a tie? Well, I'm bringing that up because there's a great headline Michael sent me. New Jersey charges itself with damaging land it was bound to protect. So if there is a legal action with a V in the middle for versus, New Jersey is on both sides of this one. Much like a wrestler wrestling himself, New Jersey's Department of Environmental Protection has issued a violation notice against itself for wrongly clearing nearly 15 acres of a wildlife management area. Wayne Perry wrote to the Associated Press, and boy, I hope they push for a harsh punishment. And by the way, will there be attorneys on both sides of this employed by the state? Seems like there's a conflict. I don't know. New Jersey's Department of Environmental Protection has charged itself with damaging habitat for threatened and endangered birds that it was supposed to protect. The work was designed to create habitat for one species of bird, but actually wound up destroying habitat for two others. The department acknowledged it sent a violation notice and threatened penalties against its own Division of Fish and Wildlife regarding unauthorized work back in February and March at a wildlife management area. It was unclear how any penalties might work when the DEP is, in essence, both the accuser and the accused. It also was not immediately clear whether any money might actually change hands. The department did not respond to questions about potential fines. I got one for you. See this? I owe myself $100. I've now paid myself $100. I've been made whole. The work involved the clearing of vegetation and disturbance of soils on nearly 3 acres of what the state calls exceptional resource value freshwater wetlands. Before the work was done, the land was considered suitable habitat for the barred owl, which is listed as a threatened species, and the red-shouldered hawk, an endangered species. Project also cleared and disturbed an additional 12 acres of land near wetlands known as transition areas, which are also protected by law. The DEP refused Friday to discuss how the work happened without authorization. On its website, the department wrote, on February 1st, the work sought to create 21 acres of habitat for the American woodcock, a member of the sandpiper family that uses its long, narrow beak to forage for earthworms in damp soil. Project was designed to create meadow habitat. I actually get those on my property. But they pass through in the spring and the fall. And they're very, very funny-looking birds, almost like something from a Dr. Seuss book. But in doing so, the state destroyed mature oak and pine forests in and near wetlands and filled in some wetlands, according to 4 conservation groups who wrote a letter to the department in early March complaining about the work. So the agency then issued a violation notice on April 6th. So they went out and did some work, and they made some mistakes. Mistakes were made. Somebody caught them. So they said, oh, well, we'll issue a notice against the wrongdoer, who is us. We have met the enemy, and he is us. The wetland soil and flora that were previously undisturbed have been destroyed, and the mature forest that was already habitat for numerous rare species of plants and birds was clear-cut logged, the groups wrote. All trees have been cut, all stumps have been bulldozed, and I'll tell you right now, it's a crying shame that it was a mature oak and pine forest. In Michigan, we have those, oak and pine forests. And oak trees are very, very cool. Pine trees can be cool also. But oaks are just these big, sturdy trees that grow to be huge, and animals love them. I'm talking about all kinds of animals, squirrels, raccoons, birds, you name it. So the trees have been cut down and the stumps have been bulldozed. The leader of the New Jersey Conservation Foundation said this never should have happened. They must also take steps to improve their clearly inadequate internal review process and meaningfully engage the public. Meanwhile, Jacqueline Rhodes, Assistant Executive Director of the Pinelands Preservation Alliance, commended the state for owning up to the mistake, but said the DEP should provide a list of current projects on its website for public review. It is because of the public that we're able to stop further destruction of this landscape, she said. And it makes you wonder, of course, if nobody called him out on it, probably nothing would have happened. Spokesperson for the agency said the Fish and Wildlife Division's Bureau of Land Management must implement appropriate soil conservation measures within 10 days and submit a plan within 30 days to restore the site. That must include removal of all the wood chips that someone placed there. By the end of April, the DEP intends to issue a notice of penalty assessment. So they've issued the order saying straighten up our mess. And they've said they're going to issue some kind of ruling. And then, of course, they will assess a penalty against themselves. Fish and Wildlife will propose additional environmentally beneficial measures, which will be subject to a public comment period. So I won't comment on this in that sense because I'm not in New Jersey. But I'm wondering if people in New Jersey might step up and ask some hard questions, such as when you charge yourself with breaking your own rules, and implicit in that is that you caught yourself red-handed. What exactly does that mean? And I'm curious, I was trying to think if I've ever heard of a situation before. I mean, I've heard of people who've outed themselves, where somebody broke the law and they stepped up and said, hey, look, unfortunately, our department just broke the law and we shouldn't have, and we did this, but we're going to come right out and say we're going to do what we need to do to make it good. But here it's a little different. They're actually saying they're going to charge themselves with, in essence, violations of the law because they damaged land that they were duty-bound to protect by law. And then the question becomes, what does that mean? And what does that notice even look like? And I mean, I've seen lawsuits. I've seen criminal complaints. I've also seen administrative complaints. And it'll say, this department, alleges the following was done by so-and-so. And when they say that we allege it was done by us, I don't even know how that works. I'm not sure anybody knows how that works. So there's almost nothing new under the sun, as they say. And so I suspect that somebody in this vast audience of mine is going to be able to step up and say, Steve, I remember something like this happening before. And so if you are familiar with any situation where an agency or a government entity charged itself with wrongdoing, please let me know, because I cannot think of any examples, and I'm not sure that I've ever actually heard of it working this way. But the good news is that they screwed up, they got caught, and the people who caught them have apparently forced them to do something to take remedial measures to straighten out what they messed up, which is good. So the result is good. It's just so unusual. So, Michael, thanks for sending it. And the story is in the Associated Press. New Jersey's Department of Environmental Protection has issued a violation notice against itself for wrongly clearing nearly 15 acres of a wildlife management area. And the sad part is that the old growth oak trees can't be easily replaced. Questions or comments, put them below. I'll talk to you later. Bye-bye.
Thank you for watching Lehto's Law. It isn't the mountains ahead to climb that wears you out. It's the pebble in your shoe.